Two of the biggest names in running are currently involved in a legal battle. Yes, Strava sued Garmin. That just happened last week. And if you log your runs, check the leaderboard, or create routes, then this one is worth paying attention to. Hey everybody, and thank you for tuning into my channel. My name is Letty. I create running content, but I'm also a lawyer. So this lawsuit is actually kind of fun for me to dissect, so let's hop into that. Strava is suing Garmin for patent infringement, breach of contract, and unfair dealing, bad faith. You can find all the legal documents by creating a Pacer account if you want to do so. Pacer is a website where you can sign up as an individual. You don't have to be an attorney. And there you can see complaints and everything that is filed. But I'm going to break all of that down for you because I took the time to actually read all of this. And according to the court documents, Strava is saying that Garmin is copying or reusing their proprietary technologies. And in this case, proprietary technologies is the stuff that powers everything, including segments, leaderboards, and popularity-based routing. So in short, Strava is saying, we invented all of this, and you're using it without our permission. In the complaint, Strava is asking for damages, attorney fees, and even a permanent injunction, meaning that Garmin could be forced to stop selling devices that use this type of technology. But before we talk more about this legal battle, let's kind of take a step back into Garmin Strava history because they were actually partners. They have been working together since 2015. Back in 2015 was when they signed the contract between each other, which was called the Master Corporation Agreement, which was basically a deal that allowed Garmin to show Strava segments on the Garmin devices. The agreement between them, however, also specified that Garmin could use these Strava segments only for Strava users within strict limits. Strava then alleges that Garmin broke that agreement and came up with its own version of the thing that they had originally invented, meaning the segments and the routing, now calling it Garmin segments and Garmin's trending routing. Now let's dive into the patent part of this lawsuit and talk about how patent law actually works, because this can get confusing. When a company says somebody is infringing a patent, what really matters are the exact numbered sections at the end of a patent. Those claims define the boundaries of what's protected, kind of like a property line, because the rest of the patent is more like a description, examples, and figures that help describe the idea, but that's not what is legally covered. And I'm saying all that just to explain that even if Garmin's features look similar to what Strava has put out on the market, what really matters is how they do it. So if Garmin's algorithms process the data differently than Strava does, or use different logic behind what they have put out, then that could be enough to avoid an infringement, which is exactly why lawsuits like this sometimes come down to what's underneath the hood and not above it. And it's really, really hard to understand for us that are not in patent law. Now, Strava got the patents back in 2014. But according to commentary online, I am gathering that back in those days, it was much easier to get a patent approved. And people are saying that Garmin already had stuff like that happening, but they were just not the first ones to file for this patent. I'm not sure how much of that is true, but as our society continues growing in all aspects when it comes to data technology, things change. Because we are all kind of new to it. Not as new as before, but we are new to it. Because back in the days, everything that we had was stuff that was tangible, stuff that we could touch. Now we own stuff in the clouds. And there was no prior precedent law that told us what we would do with an iTunes library of a person that has passed away. Now all of that is getting figured out more and more. But obviously, we are all learning. And so maybe if it is true that Garmin had developed some of these technologies before, and that Strava was just the first to file for these patents, maybe they should have never had a patent in the first place. I know that some cases like that existed in the past, not related to Strava and Garmin, and the judge in the end ended up throwing it out. So there's so much more to it, and that's why those lawyers that are working in patent law are currently making the big bucks. All right, so the big question is, why is Strava bringing this lawsuit now? And I have two answers or two speculations of mine of why this is happening now. Number one, on July 1st, Garmin announced new developer guidelines to all of their partners. And this guideline has to do with attributions. Garmin wanted more attributions starting November 1st. An attribution can mean logo placement or just saying that this data came from Garmin. And if the partners, the API partners, would not comply with that, then Garmin was threatening to cut them off, meaning that they would not sync their data automatically to Strava, that would all be done with. And that, of course, is a huge deal. All of you guys that are using Strava and you're uploading your data from your Garmin watches. Maybe you have some other watches, but I want to say the majority is probably Garmin watches because those are the ones that are most common. To Strava, this new rule probably felt like Garmin was trying to flex its muscle a little bit too much, and they pushed back. The second speculation of mine as to why this lawsuit is being brought now is because Garmin is trying to go public. Reuters has reported mid-September that Garmin has been working with investment banks to plan an IPO as early as 2026. So maybe that could mean that they are trying to boost the confidence of their investors, showing that they are serious about protecting their intellectual property and the data ecosystem that works with this story. Because if anything, even if they're not successful with this lawsuit, it does send the message that they own the innovation behind their platform and that they're not afraid to defend it. Because after all, isn't that exactly what the positioning of a company should be before they go public? That's what I was just thinking. So that's that. Now let's talk about Garmin's defense. As of yesterday, which was the last time that I checked the Pacer website, Garmin had not filed a response yet. They have obviously time to do so. But highly likely their defense is going to be that you cannot copy GPS logic and that they did not copy Strava's technology. So let's talk about what's really at stake here for both parties. For Strava, this lawsuit is all about protecting its identity as well as a social network for athletes and the technology that makes it unique. Now for Garmin, what's at stake is keeping its own ecosystem strong without needing all these out-of-network partners. In my opinion, both kind of need each other because Garmin gives us data and Strava gives us the community. And I also personally think this whole thing is kind of funny because who would have ever thought that something like a segment would spark $1 million lawsuit? I definitely did not think that would ever happen. Now let's talk a little bit about the reaction in the running community about this fight that is going on Reddit, of course. Where else? Chief Product Officer Matt Salazar posted a statement, and that statement just kind of went viral, and everybody seemed to have an opinion on it. I'm going to paste that statement right here, and you can just kind of glance over it. So basically, the Chief Product Officer said, "This is your data, runners, and Garmin shouldn't be doing that kind of to all of us." And he got a lot of backlash for that because after all, when Strava data is shared on certain platforms, it shows up and there's a Strava logo on it. So that was kind of the irony behind it. And people noticed that. Some runners appreciated it because the reactions that the statement got was that's because they felt like putting a Garmin logo on every post would be too much. But many runners were also very skeptical about what is going on and felt like this is a huge PR move on the side of Strava. Other runners have pointed out that Strava has done things like that before. And by that I mean tightening its own API access and limiting other third parties in their integration. So they called it hypocritical. But also a majority of the runners said that if Garmin cuts off Strava, they will no longer have Strava accounts and look for an alternative because after all, they have data and they want to put it somewhere to discuss stuff with the running community. Now, with all that said, let's talk about what this lawsuit means for runners. Right now, it means nothing. Right now, it means we get to sit back, eat some popcorn and wait and watch the drama unfold. Garmin still syncs with Strava and you can still post all of your segments. However, down the road, if you are a Garmin user and Strava wins, that means maybe Garmin will stop using segments or turn off some of them. Same with the popularity routing. It could mean that syncing could become more limited, or perhaps Garmin will have to pay licensing fees to Strava, which will probably trickle down to us, the users, with subscription fees or perhaps a price increase. In the best case scenario, they settle, everything gets swept under a rug, and we continue on like nothing happened. But that basically sums up what's going on right now. And I wonder what you think. Who's in the right? Who's in the wrong? Drop your thoughts in the comments, and I will keep you posted as this lawsuit updates. And hey, if you think this is helpful to your life as a runner and getting information, then be sure to hit the subscribe button. Thank you so much for tuning in. And until next time.